This is lesson 1 of unit VCS01. This lesson will cover Learning Outcome 1, which relates to relevant pieces of legislation. 1.A asks for you to be able to describe key pieces of current legislation that are relevant to veterinary practice. It is really important that you have a basic understanding of how the following legislation will affect veterinary practice, the associated staff, the clients, and also the practical application of the legislation. The relevant pieces that we are going to be looking at today are the Veterinary Surgeons Act 1966, the Animal Welfare Act 2006, the Dangerous Dogs Act 1991, the Breeding and Sale of Dogs Welfare Act 1999, the Breeding of Dogs Act 1991, and also that of 1973. We will also have a look at the microchipping of dogs regulations, and those will be relevant to England, Scotland and Wales. We will also discuss the pet travel scheme, however please note there are likely to be changes to that within the year 2019. We will also look at local authority bylaws concerning dog control, fouling, etc. Please note the text at the bottom of the slide, which states where legislation changes during the lifespan of the qualification, it is expected that the learner is knowledgeable on the most recent format. This will be very relevant to the pet travel scheme and the changes that may come into play with that this year, and also any updates to any legislations that take place. Many of these are very up to date at the moment. There may be additions here and there, and we will talk about today some recent additions that you need to be aware of. 1B requires that you would be able to provide an overview of each legislation. You must have the knowledge of when it came into force, the reason for the piece of legislation, who it actually applies to, and also how we practically apply the legislation itself, and that is particularly relevant to veterinary practice. The Veterinary Surgeons Act 1966. This is a piece of legislation that is overarching. It is pivotal to our industry, and it really does affect how veterinary practice works. The staff involved in relation to the care of animals, principally our veterinary surgeons, but there is also aspects that concern non-qualified staff and also our qualified veterinary nurses. It also relates to clients and also the needs of our animal patients, and it must be practically applied. It came into force in 1966. There have been various updates to it over time, but overall the reason for the legislation sets out that in the veterinary industry we must prevent unnecessary suffering and pain from occurring to animals. And it does this by regulating those who are allowed to provide veterinary care. No Joe Bloggs from off the street without any qualifications would be able to say that they were a veterinary surgeon and treat animals. You must have the appropriate qualification, the appropriate means of certifying that qualification. So it is not an easy process, and as you will already be aware, our veterinary surgeons take a long time completing their qualification in veterinary science in order to be able to practice, as do our nurses who wish to become an RVN. Again, time is taken to complete that necessary qualification. Overall, it does generally apply to our veterinary surgeons, but there is a part within the Act itself that we call Schedule 3. Within Schedule 3, it sets out what non-veterinary surgeons can do, and also the treatments that we can provide for animals. This encompasses the remit and responsibilities of RVNs, veterinary nurses. It also sets out within the same schedule what can actually be carried out by owners of pets, farm animals, so in relation to our farmers, lay staff, and actually who is also allowed to legally provide first aid to animals. When we are practically applying this legislation, it is relevant to day-to-day veterinary practice. It is relevant because it dictates who can do what. So, for example, only veterinary surgeons are actually allowed to perform veterinary surgery. Within Schedule 3, it does encompass, as we said, the remit and responsibilities of our RVNs. So RVNs are allowed to perform minor surgeries, but that is only the case if the veterinary surgeon responsible for the animal's care is happy for them to do so, is happy that they are qualified in order to do so, that they are competent to do so as well. It also does, within Schedule 3, look at the allowances of student veterinary nurses as well and what they're allowed to do. But the veterinary surgeon must be happy that the person they're asking to perform that task is either training or is qualified and is competent to do so. And the sorts of things that nurses may wish to do if they wish to have an interest and want to perform Schedule 3 procedures is things such as minor stitch-ups, minor lump removals. However, it does not allow nurses to enter a body cavity. That is only enabled to be done by our veterinary surgeons. And again, only our veterinary surgeons can make a diagnosis of an animal's condition. This does not come under the remit and responsibility of RVNs. So the reason that we have to adhere to this piece of legislation is so that only those that are appropriately qualified and are competent to do so carry out treatment of animals. The reasoning behind that, furthermore, is to prevent unnecessary pain or suffering being caused to our animals that are in our care. This information has been gleaned from the RCVS website, and I have provided information of a link there which would give you information regarding the Veterinary Surgeons Act 1966 in nice bite-sized chunks. You can look up the Act itself, however the link to this RCVS page is far more appropriate. This piece of criteria does relate to any portfolio task for you to complete. So it would be very relevant if you wish to do further reading that you carry that out in order to be able to complete your task well. The Animal Welfare Act 2006. Unfortunately, prior to the Animal Welfare Act coming into force, in relation to the law regarding animal welfare, we would generally have termed it as reactive. Unfortunately, this meant that action to perpetrators could only actually be taken once an animal had suffered unnecessarily. That is the reasoning for this Act coming into play in 2006. When it came into force in that year, it was introduced as an important and new concept for pet owners. But it also covered those that were responsible for animals' care. So in relation to domestic animals, that would also include breeders, those who have working animals or farm animals, and also those that are caring for animals in a caring format, so those acting in pet shops, kennels, catteries, veterinary practice. So it does apply to an awful lot of people. Within Section 9 of the Act, it importantly places a duty of care on people to ensure that they are taking all reasonable steps in all relevant circumstances in order to actually meet the welfare needs of animals in their care. And this welfare need is being talked about in relation to good practice. Animals should be cared for appropriately as per their species, age, breed, condition, just to name a few. Again, the Act is pivotal in relation to animal welfare in order to prevent animals from suffering in any form. It also does mean that now enforcement agencies such as the RSPCA and those inspectors that work for the RSPCA can now act in the first instance initially by advising and educating owners and animal carers. And this is before those animals suffer. Obviously, if that advice is then not followed through by the animal's carer or owner, or their needs are still not being met, then that would mean that action could be taken. And that might include a simple formal warning, or in some cases prosecution, depending on the severity of the situation. The RSPCA are very heavily involved in the Act, and there's some really useful resources on their website, which we'll come to talk about further in a moment. Those responsible for the care of animals, whether they are the owner or carer on behalf of the animal, they must ensure that the welfare needs are met, and in particular they must provide the 5 welfare needs. Please note, they did used to be called the 5 freedoms. This has now been updated and we do know them as the 5 welfare needs, and thus the relevant wording in relation to those needs is now as follows below. The needs that we must consider are the need for the animal to have a suitable environment. Again, please note this environment must be relevant for the species of animal, the breed, the animal size, situation, for example, a pregnant animal, a breeding animal, etc. So that environment must be suitable for that animal. Sometimes we may house animals together or apart, and that also needs to be considered. The animal must have a suitable diet, again in relation to their species, breed, health status. We must cater appropriately with the diet that's provided, and sometimes animals, in particular in relation to veterinary practice care, may require a prescription diet for a certain type of condition. So again, that's a slight difference, but an owner must provide that to be appropriate. The animal must be able to exhibit normal behaviour patterns. So again, the environment, the substrate, the fixtures and fittings within that environment, the size of the environment, heating, lighting, providing, situations such as nocturnal setups or daytime setups, they're all really important. And to know what a normal behaviour for that animal is, that owner or carer must actually research what is normal and link it to these other aspects in order to be able to provide it. Some animals need to be housed with other animals if they are sociable. Other animals are not sociable, so they must not be housed with other animals. So again, it's important to know, is this animal appropriate to be housed with other animals? It may be that in the past you may have been aware of, for example, guinea pigs and rabbits being housed together. Actually, that isn't all that appropriate. They don't need or have the same requirements when it comes to some of those needs that we've already talked about, and actually can actually make each other quite poorly because of those differences. Overall, and the overarching need here is that in providing the above and providing the care for the animal, they need to be protected from pain, suffering, injury and disease. So in order to be able to do all of those, the relevant owner or carer must have the knowledge of how to provide those 5 needs correctly. When we're practically applying this to veterinary practice, we must have this knowledge as well. And this will all come as part of your training and your training in the future if you progress on to level 3. So as a staff member who is caring for patients within the veterinary practice, you must abide by these 5 welfare needs. And if you're at all unsure, then that is when you can approach your qualified members of staff to advise you appropriately. Also, this is very relevant when we come across cases of neglect or mistreatment, where veterinary surgeons may be involved in court cases in order to make sure that people who haven't abided by these needs or who have mistreated and potentially abused an animal would actually suffer the required penalty. So, as I said, this law came about in 2006. The RSPCA, and especially the website link here that I provided for you to look into further, provides lots of information in relation to the Act and the changes that came about. It also provides lots of educational information that you yourselves could utilise, but also that could be utilised in veterinary practice. And that is vitally important. So please utilise that link to the best of your ability. The Dangerous Dogs Act 1991. Within Section 1 of the Dangerous Dogs Act, 4 types of dog are identified: the Pit Bull Terrier, the Japanese Tosa, Dogo Argentino and Fila Brasileiro. The Act makes it illegal to own, sell, breed, give away or abandon one of these types of dogs. We term them as the banned breed. Within early 2019, this is an Act that has been looked into, and there has been an awful lot of information in February in relation to government input on it and what we can do to try and change it. There's an awful lot of concern about this piece of legislation because of some parts of it. However, we must ensure that we are advising people correctly in relation to the Act. The Act itself applies to owners and it replaces the responsibility with them. In some situations, it may actually be necessary for them to register their dog. And the purpose behind the Act is intended to keep the public safe from dog attacks. It does, however, remain one of the UK's most controversial pieces of legislation. This is because when we are talking about such banned breeds, that is actually based upon what it looks like. So if an owner has a dog which has many of the characteristics of a Pit Bull Terrier, it may be considered a banned breed. The owner of the dog must ensure that the dog is under control at all times, and this can include ensuring that the dog is muzzled and that it is walked using a secure lead. When it comes to the relevance to veterinary practice, we must take care to ensure ownership, or that being the keeper of the dog is very clear, and take care when dealing with an animal that may be legally construed as dangerous, but which the owner may not treat in that manner. So we must have an awareness of it. Our qualified veterinary team must be able to advise people appropriately on the legislation, but we must adhere to it. Breeding and Sale of Dogs Welfare Act. This covers acts within 1999, 1991 and 1993. And that is because the Act that came into force in 1999 amended and extended the provisions of those acts already in place. And it already provides protection for dogs used in breeding establishments. It just built upon those. Any person who keeps a breeding establishment for dogs at any premises and carries on at those premises the business of breeding dogs for sale must obtain a licence, and that licence is obtained from their local council. We also do have people that are not in the business of breeding dogs for sale as a general day-to-day living, when we would call them hobby breeders, and that would mean that they would actually produce less than 5 litters in any 12-month period, and that means that they do not require a licence in order to do so. It is up to the local council whether to grant a licence or not, so it is up to their discretion. And before doing so, they must ensure that the person responsible actually satisfies the following criteria. This again relates to animal welfare, as we've already talked about, and so some of these will be similar to what we talked about in relation to the Animal Welfare Act. So the animals are provided with suitable accommodation, food, water and bedding material. Again, that is relevant to their species, breed and also their health status. They must be adequately exercised and visited at suitable intervals. They must ensure that all reasonable precautions are taken to prevent and control the spread of diseases. So animals must be vaccinated, they must be wormed and fleed appropriately, and again the conditions that they're housed in will assist with that also. As we've already said, the local council is responsible for enforcing that legislation, so they must check on these breeding establishments on a regular basis, and certainly on an annual basis it is relevant for the licence to be renewed. In addition to ensuring that the dogs are kept in suitable accommodation, the law also places limits on the frequency and timing of breeding from a bitch. Bitches cannot be mated before they are a year old, as they're still a puppy themselves. They must have no more than 6 litters in a lifetime and can only have 1 litter every 12 months. Breeding records must be kept to ensure that these requirements are being adhered to. And puppies that are produced at such a breeding establishment can only be sold at these premises or a licensed pet shop. Unfortunately, you're probably very aware of the fact that at the moment the UK has a really severe problem with puppy farming. And this is something that is being looked at, and we will cover that in a moment. The following slide is a task for you to complete. I have provided the links below in order for you to have relevant links to use to help you research and make notes on the changes to the 2006 Animal Welfare Act. We didn't talk about these in relation to the slide previously when we were covering the Animal Welfare Act because it relates to puppy breeding. What I would like you to consider that when you are making these notes and you're doing the research is that you are very aware that the above changes to the legislation have come into force due to the severe issue that the UK unfortunately has in relation to puppy breeding, and it means that we require stronger legislative support and controls. You may be very aware of the phrase in relation to going and visiting a puppy, that it's really important to go and see puppy in their home setup with their mom present, and if at all possible also the dad present. But unfortunately it's become commonplace for this not to be the case, and people are meeting dog sellers in car parks, in lay-bys, and unfortunately they know nothing about that puppy's background, they know nothing about mom. And unfortunately, it is very likely that in that situation that animal has not come from the appropriate background, that they are a farm's puppy, and that can mean that they can have some awful health issues and conditions. And in some situations, such issues can be fatal. So it's really important that we get on board, we're aware of these changes to legislation in veterinary practice, and that we can advise and correctly educate owners. I've also provided for you a link to an article from the Kennel Club, and this looks further into the issues that relate to puppy farming. And again, I would really advise that you look at that and use it to further educate yourself about the issues that can occur. Microchipping of dogs regulations. Please note that in England this came into force in 2015 and in Scotland and Wales 2016. We had an awful lot of information at the time of this regulation coming into force in the UK, England namely first of all, in order to enable owners of dogs to ensure that dogs that weren't microchipped were done so. We were provided with a time frame, and that stipulated that from the 6th of April 2016 that all dogs needed to be microchipped, and that was a legal requirement. So there was a nice time frame prior to that to ensure that dog owners could meet this requirement. They had the time to get that booked in and ensure that their dog was microchipped. So after the 6th of April 2016 in England, it became a legal requirement that any dog must already have a microchip if they weren't a puppy, and that all puppies must be microchipped. Veterinary practices must be ensuring that this is carried out, so it is now part of those first few visits to the veterinary practice at the time of a first or second vaccination, and practices must have protocols in place to ensure that that is the case. The reasoning behind this is to help to improve dog welfare. That is the main purpose behind it. If a dog strays or is lost, if they're microchipped, we can far quicker find their owner using this information. Now, alongside the fact that the dog needs to be microchipped in the first place, it is also essential that their details are kept up to date with the microchip company. So owners must ensure that change of address, any change of telephone numbers, any change of details at all from that point of view, that they inform the microchip company. Now, there does tend to be a small charge for doing this, an admin charge for updating those details, but that is essential. Without those details being up to date, then we can't set out to achieve the purpose of the microchipping in the first place. It is also useful where we have situations where we may need to track down owners of dogs where unfortunately an attack on a person has taken place. Also in the UK at the moment, we are unfortunately seeing a rise in dogs that are being stolen to be sold on again or to be used to be bred from. Again, if dogs are microchipped, then if veterinary practices are routinely scanning patients, then hopefully we can pick up where details do not match and hopefully be able to identify a situation far quicker when an animal has been stolen. I have provided you with a task here that I would like for you to complete, and there is a provided link that you could utilise to access to assist you with this. And what I would like you to do is make some notes regarding timescales and also potential penalties for not microchipping your dog or puppy. What I would also like for you to do as well is find out, if you do not know already, how your practice actually complies with the above legislation in relation to microchipping of puppies. So where in relation to those first few visits, is it at the time of a first vaccination, a second vaccination for example? What is your practice procedure for making sure that is met? And also, how do you routinely check dogs that are not puppies, that chips are working, that they haven't moved? You make notes and things like that. And are you also checking with clients that they're updating details? So please complete that task and upload it onto your OneFile for your educationist to check. The Pet Travel Scheme requires various aspects to be adhered to enable the safe travel and return of animals to the UK. An animal can only initially enter or return to the UK if certain criteria has been met, and this applies to cats, dogs or ferrets. Your animal must have been microchipped. They must have a pet passport or a third country official veterinary certificate. They must have been vaccinated against rabies, and if travelling from a country that we class as unlisted, the animal would also require a blood test. It is also normal practice for dogs to have had a tapeworm treatment. If these pieces of criteria are not adhered to, then your animal could be put into quarantine for up to 4 months, or if the animal has returned or is travelling to the UK by sea, refused entry. At this point in time, the owner would be responsible for the fees or charges. It is very important that you're aware of the upcoming and impending date of the 29th of March 2019 in relation to Brexit. If by this point in time the UK were to leave the EU with no deal in place, then there is likely to be very big repercussions in relation to the pet travel scheme. It will be really important that you, as part of your practice team, ensure that you are fully informed about the changes that will come in, and also the DEFRA website is a fantastic resource to provide you and the rest of the practice team with information about the changes. Local authority bylaws. Local authorities or councils have bylaws in place. It is really important the public adhere to these in order to be responsible pet owners. You may be very familiar with some of these, however, just to clarify some key points about them. Dog fouling. If an owner does not clear up after their dog following fouling in public, then they can be given an on-the-spot fine. The amount will vary from council to council. Very often it's in the region of around £50, but it can be as much as £80. If the owner of the dog at that point in time refuses to pay the fine, then they can be taken to court and fined up to £1,000. The reason behind this is that it is essential to keep the public, and when we're talking about the public, we are considering especially children, safe from the harmful parasites that faeces can harbour. Dog control. In relation to this, if we find a lost or stray dog, we can report it to our council, who will have their own dog warden, who will collect the dog and take it to the kennel establishment that they use locally. The reasoning behind this is to keep the animal safe, ensure that they don't come to any harm or harm others, and also then to be able to trace the animal's owner and ensure that the dog is reunited with them. We can also report to our council dog warden any concerns regarding dangerous dogs as well. In summary, within today's lesson, we have covered Learning Outcome 1A, current pieces of relevant legislation that are related to veterinary practice. We have also covered 1.B, which related to providing an overview of each legislation. Hopefully, onwards from today's lesson, you should have a basic understanding of how the legislations that we covered affect veterinary practice, ourselves as staff, clients, and also the practical application of the legislation, and also who the legislation is about, and ultimately, as we have seen, the vast majority of reasoning behind the legislations that we've covered are related to animal welfare and our purpose in relation to that. This learning outcome and the aims related to it are also an e-portfolio task for you to complete, so please utilise any of the links provided to look into aspects further, to build upon the information provided to you within the PowerPoint, and to better explain in your own words your understanding of the pieces of legislation that we've covered. Again, just to remind you that if there are any changes to these pieces of legislation during your time on programme, please ensure that you make sure that you're up to date with the most up-to-date version. As a centre, we will provide you with information surrounding such things, as your practice will, in the necessary nature of being up to date from a practice point of view, but it is essential for your studies, and if you are progressing on to level 3, that you are very aware of any changes. Again, just to highlight some of those changes that we have talked about in the PowerPoint are the changes to the Animal Welfare Act in relation to breeding, to try and overcome the issues that we have surrounding puppy farming currently, and also the upcoming changes to the pet travel scheme that at the moment we are very unclear of, but be aware of that date of the 29th of March that we are working to currently, to ensure then that you're keeping yourself up to date with those changes. And again, the DEFRA website will be a really useful source of information for yourself and your practice team regarding that.